everyone, Calvin Davis here with KeyRenter Richmond Property Management. If you're a landlord in Virginia, understanding the eviction process is absolutely critical to protecting your rental property. Evictions are never fun, they are stressful, they are time-consuming, and if you handle them incorrectly, they can cost you serious money. Today, I'm going to walk you step by step through the eviction process in Virginia, so you know what to expect and how to protect yourself legally. If you find this helpful, be sure to like and subscribe for more Virginia landlord tips. Let's jump in. When can a landlord legally evict in Virginia? In Virginia, landlords can evict tenants for several reasons, including non-payment of rent, lease violations, criminal activity, and refusal to vacate after the lease expiration. But here's the key. You cannot simply remove a tenant because you're frustrated. Virginia law requires landlords to follow very specific notice procedures before filing with the court. Step 1, provide proper written notice. The type of notice depends on the reason for eviction. For non-payment of rent, Virginia requires a 5-day pay or quit notice. This gives the tenant 5 days to either pay the full balance owed or vacate the property. If the tenant pays within those 5 days, the eviction process typically stops. For certain lease violations that are curable, meaning the tenant can fix the issue, landlords often must provide a 30-day notice with 21 days to remedy the violation. For non-curable breaches, different notice rules may apply. The biggest mistake landlords make: incorrect notice language, incorrect notice delivery, or incorrect timelines. If the notice is defective, your case can be dismissed in court and you have to start over. Documentation is everything. Filing an unlawful detainer. If the tenant does not comply with the notice, meaning they don't pay or don't correct the violation, the next step is filing an unlawful detainer in the General District Court. This is the formal eviction lawsuit. Once filed, the court schedules a hearing date. The tenant will be served with the court paperwork, typically by the sheriff. At the hearing, the judge reviews the lease, the notice served, the payment history, and any supporting documentation. If the judge rules in favor of the landlord, the court will enter a judgment for possession and possibly for unpaid rent and fees. Step 3, writ of eviction and sheriff removal. Winning possession in court does not mean you can immediately change the locks. If the tenant still refuses to leave, you must request a writ of eviction. This authorizes the sheriff to schedule a physical eviction. The sheriff will post notice of the eviction date and return to the property to supervise the removal. Only after the sheriff executes the writ can the landlord legally regain possession. Self-help evictions, like changing the locks or removing belongings, are illegal in Virginia and can expose landlords to liability. Quick plug here. One of the best ways to avoid evictions entirely is strong tenant screening and proactive rent collection. At KeyRenter Richmond Property Management, we handle professional tenant screening, consistent rent collection, lease enforcement, and eviction coordination when necessary. Our goal is simple: prevent problems before they turn into court cases. If you own rental property in the Richmond area and want help reducing eviction risk, visit KeyRenterRichmond.com/schedule. Now let's talk about timing. How long does the eviction process take in Virginia? Evictions in Virginia can move faster than some states, but they're rarely immediate. From the initial notice to sheriff execution, the process can take several weeks at minimum or longer if the tenant contests the case. Court scheduling, tenant defenses, payment disputes, or filing errors can all extend the timeline. And every additional week for you means lost rent, ongoing expenses, and more stress. That's why accuracy from day one is critical. Important things the landlord should never do. Let me emphasize a few things clearly. Do not shut off the utilities. change the locks, remove doors, harass tenants, remove belongings. Virginia law prohibits self-help eviction tactics. Even if a tenant hasn't paid in months, you must follow the court process. Trying to shortcut the system can result in the landlord owing damages to the tenant. Prevention is always better than eviction. Evictions should always be the last resort. The best way to avoid them? Thorough tenant screening, clear lease agreements, and consistent enforcement. Proactive communication, fast response to early warning signs. At KeyRenter Richmond, our screening process includes credit evaluation, income verification, employment checks, rental history verification, background review, and consistent fair housing compliance. Strong screening significantly reduces the likelihood of non-payment and lease violations. Evictions usually start long before the court date. They start with poor screening or inconsistent enforcement. Some final thoughts. Let's recap the eviction process in Virginia. Number 1. Serve the proper written notice. 2. File an unlawful detainer if unresolved. 3. Attend the court hearing. 4. Obtain a writ of eviction if necessary. 5. Allow the sheriff to restore possession. Evictions are procedural. Follow the law exactly. Document everything and never attempt self-help removal. As always, this video is for general informational purposes only and is not legal advice. Laws can change and every case is unique. Always consult a licensed Virginia attorney before taking action. If you found this helpful, give this video a like and subscribe for more Virginia landlord education. And if you'd rather not handle eviction filings, court appearances, and legal paperwork yourself, visit KeyRenterRichmond.com. I'm Calvin Davis with KeyRenter Richmond Property Management. Thanks for watching, and I'll see you in the next video.